Hello everyone, welcome back to our session on Insolvency and Bankruptcy Code. Let us resume our session on CIRP process and continue from where we left off. So, as I've told you in the previous session, the IRP or invites claims through a public announcement via a paper publication and also notices published on the IBBI website, and he invites claims from all stakeholders of the corporate debtor. So, claims of each of the stakeholders are invited via different forms as provided by the IBBI on the website. So, financial creditors submit their claims under Form C, and they are required to submit the Form C mandatorily via electronic medium to the resolution professional or the IRP. So, for them to substantiate their claim, it is necessary for them to submit proofs along with the claim. Such proof can include evidence of claim, can include any record with the information utility indicating towards this claim, or a financial contract or a loan agreement or such other agreements which indicate to this particular financial transaction, or it could be financial state account statements or any order or decree of the court or such other evidences which can be used to substantiate a financial debt. So an IRP or an RP is required to look for these records of financial debt, and upon his satisfaction of the debt may admit the claim of the financial creditor. In a similar manner, an operational creditor submits their claim under Form B. Any operational creditor other than workmen and employees, they submit Form B, and they are also required to submit such other evidences which may aid in substantiation and admitting the claim. So for them, any record with the information utility or any invoices or contract purchase orders and account invoices raised and in account statements indicating that such invoices have not been honored and such other evidences. Workmen and employees may submit their claims if they are being submitted on an individual basis under Form D. But if there are numerous employees, if it's a large scale organization and there's multiple employees and workmen and they would like to submit their claims as a group put together and name one representative, they may do so under Form E. Form E is essentially a bulk form where all of the employees and workmen can come together and submit their respective claims. So with that, they will have to annex record of employment and the extent of dues, and if this kind of dues have been recorded in the information utility, those, and if any orders of any tribunal or respective adjudicating authority or such other records, if any, have to be annexed with the form. And there is a separate category called other creditors as provided by the IBBI. So such other creditors who do not fall in the category of either operational creditors or financial creditors may submit their claim under Form F. So towards such creditors, neither an operational debt nor a financial debt is owed. For instance, any seller of an immovable property, suppose, and the corporate debtor has defaulted on such a transaction, they may file their claim under Form F. So all such claims are collated by the IRP or the RP and verified, and subsequent to such verification, the claims and the respective amounts to which the IRP is satisfied may be admitted. Here, the IRP or the RP does not play an adjudicating role of any sort. He merely assesses the claim amount based on the documents received by him and the evidences placed before him. He does not play any sort of adjudicating role. So once these claims are collated and verified, the the IRP then submits a report, a committee of creditors constitution report, to the adjudicating authority. And upon such filing of the constitution report, a COC is considered to be constituted. And from that point onwards, the committee of creditor presides over the CIRP process. It's still going to be either the IRP or the RP who acts as the chairman of all of these committee meetings. However, the decision-making authority is solely in the hands of the committee of creditors. The all financial creditors of a corporate debtor will be made a part of the committee of creditors. If in case there are any financial creditors who are also an operational creditor, or if a financial creditor who has received an assignment or a transfer of an operational debt, such financial creditors will be considered financial creditors only to the extent of the financial debt owed to them. And to the extent of the operational debt owed to them, they will be considered as operational creditors. So the voting share that they will be possessing is going to be towards only to the extent of the financial debt owed to them. So let's understand how the voting share is calculated. So when the IRP submits the constitution report along with uh, the claim amounts received, he also calculates the extent of the financial debt. So the total financial debt and individual and the debt owed to individual financial creditors. So the percentage of the debt owed to each of the financial creditors would be the voting share owed to them. So if either the financial creditor directly or through a representative, if they're appointing a representative or a nominee to appear on their behalf and participate on their behalf in the meetings of the committee of creditors, then they may do so with they may appoint an authorized representative who is going to be an insolvency professional other than the insolvency professional acting as the IRP or the RP. Such insolvency professional may participate on their behalf at their own cost, at the cost of the financial creditors, and act as per the financial creditors' interests and decisions. And they will act merely as a representative body. They will just get instructions from the financial creditors on a prior notice and then participate accordingly in the committee of creditors meeting. And in case of a class of creditors, as I have told you previously, in case there are a class of creditors, then the IRP, while giving a public announcement, provides a choice amongst three insolvency professionals, unrelated insolvency professionals, in the public announcement itself, and gives a choice to the class of creditors to pick one of these insolvency professionals who is going to act as their authorized representative in the committee of creditor meetings. So upon receiving the claims, while collating the claims, the IRP is to take note of who the authorized representative is going to be and communicate such appointment to the authorized representative, to the LOTs, to the COC, and to the adjudicating authority. This authorized representative, similar to IRP, should also submit their consent, and also they should not have any disciplinary proceedings pending against them. They will be representing the interests of the class that they represent, that the class that has appointed them. They will be acting solely in the interest, solely in continuation of the interests of the class that they're representing. If in case they have not received any voting instructions, then they will wait on the vote. They cannot act independently from that of the class of creditors. So in a class of creditors, the voting process is slightly vary. The allottees, the authorized representative will take a decision amongst the class of creditors, and any decision with a simple majority will be considered, and such decision will be made. Such decision will be voted in the meeting of the COC. If suppose, say the committee of creditors are trying to decide on whether or not to take an interim finance, and there is a simple majority amongst the class of creditors that that the interim finance is required to be taken, then the authorized representative will go and vote that the interim finance is required to be taken in the COC meeting as well. However, the voting process, this stays constant. The voting process for the allottees or the class of creditors stays constant for every single decision that the COC might take. However, the only exception here is in case of withdrawal. So Section 12A provides for withdrawal from the COC process, and such withdrawal must be backed by 90% of the voting share. So in case financial creditors, if they vote with 90% majority, if withdrawal is voted for, then the application may be withdrawn. And an application for withdrawal also will be made by the resolution professional or the IRP before the adjudicating authority, and the withdrawal can then be accepted. In case of class of creditors, whoever, to whatever extent, it's not a simple majority. To whatever extent the class of creditors vote for withdrawal, that extent will be communicated over there, and whoever states that the withdrawal should not take place, then such extent will be reflected in the COC votes as well. Like supposing, say, about 25% of the class of creditors are for withdrawal and 75% are against withdrawal. So the IRP will vote individually to that extent. 25% will be towards against the withdrawal motion and 75% for the withdrawal motion. Okay. And now that we have understood the voting share, we will proceed. In case a corporate debtor does not have any financial creditors, then a committee of creditors may be constituted with operational creditors. The CIRP regulations provided by the IBBI states that 18 largest operational creditors, if there are 18 largest operational creditors, or if any such lower number, all of the operational creditors, and one representative of employees and workmen, and So such operational creditors will be made part of the committee of creditors. And the voting share will also be calculated against the total debt, because there is no financial creditors. All of the operational creditors' debt will be considered as a total, and each individual operational creditors, uh, the debt owed towards them will be considered as the voting share that they possess. So let us understand what is the voting percentages. So in most cases, for any important decision taken by the committee of creditors, a mandatory 66% majority is required to be obtained. Section 28 provides that any such decisions will require 66% majority. And these decisions may include raising of interim finance, replacement of RP, or appointment of internal and external auditors, or sale of assets, and such other resolution approval or rejection of resolution plan. Such other decisions of the COC need at least 66% of the voting majority. For conducting of, let us understand the process in which the COC meetings are conducted. So the IRP or the RP, before conducting a meeting, it is required to send across an agenda of the meeting to the members. Members as, okay, and in the COC meeting, any financial creditor will necessarily be given a seat and will possess voting share as well. Other than the financial creditors, the uh, the operational creditor who has a debt aggregating over 10% of the total debt, and the erstwhile management of the corporate debtor will also receive an agenda of the meeting and be invited to take part in the meeting. But their absence in the meeting, or if they are not, for some reason, not invited to the meeting, does not invalidate any of the decisions taken in the COC meeting. So once the agenda is given, at least a 5-day notice period is to be given before the committee of creditor meeting is scheduled for. And that notice period may be reduced to not less than 24 hours with the prior approval of the COC. But in case there are class of creditors, then the notice period cannot be reduced for less than 48 hours. Once the agenda is issued and the meeting is called for, meetings can be called for either virtually, since the facilities and everything, it was actually necessitated by COVID, but it has become a common practice, and it's also a preferred option considering that the assets and the financial creditors are located at several different areas. So this is a quicker process. So the meeting is scheduled. Once the meeting is commenced, the IRP acts as the chairman for the meeting. He calls for the attendance of all the people attending, all the participants, and if the meeting does not have sufficient quorum, at least 33% of the financial creditors possessing voting share to 33%, to the extent of 33%, must be present in the meeting. If they are not present, then the meeting shall be adjourned for the immediate next day, 24 hours from then. And once the agenda has been, once the attendance has been recorded, then the IRP generally proceeds with the agenda. So once the discussion is done, the IRP or the RP creates a voting sheet and seeks for votes from the committee of creditors. Voting can either take place in the committee of the in the meeting itself or subsequent to the meeting. Also, the voting sheet will be shared, and the votes may be received at a later point, as decided by the members of the committee. So, once the meeting is concluded, the within 48 hours of conclusion of the meeting, the IRP or the RP will issue the minutes of the meeting, along with which they may also issue the voting sheet. So the voting must be open at least for a period of 24 hours for the members to vote. And then the authorized representative will be sharing the agenda of the meeting to his class of creditors that he's representing, the minutes of the meeting that he has received, and voting sheet as well, so that they can communicate their interest to the IRP, to the authorized representative first, and subsequently he will cast his vote accordingly. After receiving such votes, then the RP or the IRP may proceed along the same lines. So for the appointment of professionals also, the IRP is required to take the approval of the committee of creditors. The code provides that the IRP or the RP must appoint a valuer, a registered valuer, for assessing different asset classes. A registered valuer will be for three categories of assets: for plant and machinery, land and building, and securities and financial assets. So these registered valuers will be appointed. The IRP or the RP, before the 40th day from the date of commencement, has to appoint a registered valuer. So the registered valuers, two of them have to be appointed. All right. So they have to, ordinarily the procedure in appointing is, from a practical aspect, I mean, IRP or the RP will invite quotations from various valuers, and they put these quotations and the profiles of the valuers before the before the committee of creditors, and upon their inclination and decision, two registered valuers will be appointed. Two registered valuers for each class of assets. Two valuers for plant and machinery, two for land and building, and two for securities and financial assets. So these valuers will create a valuation report based on the financial data or for SFA, and whatever they make their assessments after going to the site for the plant and machinery and land and building. They calculate the depreciation and the state in which the machinery is in, and the amortization. All of these things are taken into consideration, and all of the asset classes will be valued. Once this valuation is done, then this is provided to the committee of creditors. So basically, this aids the committee of creditors in voting once the resolution plans come before them. Once the resolution plans are placed before them, they may take their decision based on the valuation provided. If the valuation of the company is, say, suppose 100 crores, and the resolution plans are to the extent of, suppose, say, 150 crores or so, then naturally they will be inclined to go for the resolution plans, because the value of recovery being realized in the resolution plan is much higher. If the resolution plans received are lower than the valuation, say suppose the valuation in this instance is 100, and the resolution plans, the highest amount in the resolution plan received is supposing around 70, and if the negotiations also fail with the COC, then they may vote for liquidation. The members of the committee of creditors may take their decision based on the viability and feasibility. They take their commercial decision based on the valuation placed before them. Similarly, the IRP or the RP is also required to appoint a transaction auditor. A transaction auditor is given all of the financial details and documentation required to assess if there are any uh, avoidance transactions, essentially. And we will be learning about these avoidance transactions in detail in the subsequent portions of our sessions. The members of the committee of creditors may also replace the resolution professional himself. If for some reason they are not able to function with the resolution professional, or they have some issues, or if the resolution professional himself wishes to withdraw from the proceedings, then they may replace the resolution professional. Again, a 66% voting majority is required for even replacement of the resolution professional, and they must also suggest the insolvency professional who is to replace the resolution professional, and such insolvency professional must have must meet all of the criteria of a resolution professional. He should submit his consent form. He should not be a related party. He should not have any disciplinary proceedings pending against him, and such appointment may take place. Now let us understand the eligibility criteria under Section 29A. So for inviting resolution plans, the insolvency professional publishes a public announcement in the newspaper, and again is also uploaded in the IBBI website. And also, if the corporate debtor, even in the initial instance also, the newspaper publication, the Form A paper publication, or the public announcement inviting claims is also reflected on the corporate debtor's website if they have one. So the resolution professional again gives a public announcement in the newspaper inviting expression of interest from various prospective resolution applicants. This is called a Form G announcement. So once the resolution professional invites expression of interest, they can expect prospective resolution applicants. So these prospective resolution applicants must meet with the eligibility criteria under Section 29A. So Section 29A essentially talks about the ineligibility of bidders, actually. So any person who is not who is ineligible under 29A will be excluded, and such other people may be submitting a resolution plan. So this 29A was brought in to prevent defaulting promoters of the corporate debtor to get into the process again, or any other person who has a history of defaulting or such people from bidding in the process, which ensures only credible entities to take over. If once the bidding is concluded and their resolution plan gets accepted, and the prospective resolution applicant fails to comply with the procedure, or say suppose he does not manage to actually uh, conclude the resolution process as envisaged in the resolution plan, then that creates trouble, and that might bring the stakeholders to the position where it was in the prior instance, prior to the CIRP. And it's actually much worse considering the liquidation value and the valuations of the assets also might have changed by then. And due to the environmental factors, if a company has gone to the extent of resolution and then goes back to the scratch, then the costs involved also sets it back. So it is very important for the prospective resolution applicants to be credible, and this avoids and ensures that there is no misuse of the resolution process. So once the expression of interest is received, they are also required to, the prospective resolution applicants are required to submit a profile of uh, of whoever the entity is, which may include the details like uh, whichever may enable the IRP to ascertain their credibility and financial solvency. They are also required to submit an affidavit stating that they do not fall under the ineligible people identified under Section 29A. And most importantly, they're also required to submit a confidentiality undertaking. So, in the process of bidding in a CIRP, they will be provided with information memorandum and documents of the corporate debtor that may be confidential, which will enable them to assess and make their bid. So it is crucial for them also to understand what are the assets and liabilities of the company for them to make a bid in the first place. So for that to happen, they will be able to access confidential information, and it is pertinent that they will not divulge this confidential information to any other third parties, or will not use the copyright of the corporate debtor, if any, made available to them to a third party, or use it for their own benefit if they are not participating in the if they are not the successful resolution applicant as well. So once this preliminary process is done, the resolution professional at that instance will create a provisional list of prospective resolution applicants. So this provisional list of applicants will be provided an information memorandum, and the details of any other details that the members of the committee of creditors may deem to be important. Once this takes place, after assessing that they are credible and that their portfolio checks out with the eligibility criteria laid down by the members of the committee of creditors, then the resolution professional will confirm their eligibility to participate in the proceedings by issuing a final list of resolution applicants. So the prospective resolution applicants will be able to access an information memorandum, a bid evaluation matrix, and criteria for eligibility criteria. So the eligibility criteria is given at the initial instance itself. A bid evaluation matrix, or a BEM, includes the criteria on which the members of the committee are going to decide the resolution plans on. So it can have quantitative and qualitative criteria and marking for each of such criteria. Say suppose there is a hospital that is undergoing CIRP and it's a going concern. So the members of the committee may also, in the interest of it being a going concern, also consider the background of the resolution professional, resolution applicant. They may require the resolution applicant to have a certain amount of industry experience because hospital is a very specialized field. You cannot expect a lay person to come and manage such an institution. So they will have to, they may impose certain qualifications and criteria like their educational background or their financial background or like supposing their licensing and everything. So ordinarily during the CIRP period, even after the moratorium is imposed, any licensing held by the corporate debtor will continue to be valid as long as that any amounts due for that licensing are not defaulted. So in the hospital example itself, uh, if in case a specific license is given to the cardiology or to do some sort of innovative surgery, then that licensing may continue for as long as the predetermined period, not merely because the CIRP is commenced, does it get put on hold. But once a PRA steps in, because the management has changed, the licensing may also have to be taken again. And the licensing period, the mandatory minimum period for obtaining such licenses is also to be included in the resolution plan that they're going to submit. And it shall not be over a period of 1 year. Now, coming back to the actual resolution plan itself. So the final resolution, once the final list of resolution applicants is given out, the bidders may submit resolution plans to the RP. A minimum period of 30 days is provided by the RP to submit the resolution plans, and then an extension also may be given if the COC permits. Once the resolution plans are provided, then each of the PRAs will be given an opportunity to present their profile and to present their resolution plan, financials of their resolution plan to the members of the COC. So then, in the meeting of the COC members may interact and negotiate with the PRAs as per their commercial wisdom. So the PRAs are also allowed to sit in the meetings of the COC only in the meeting where their specific resolution plan is being discussed. But if in case the prospective resolution applicant is also a member of the COC in the capacity of a financial creditor, then he may participate in the process, the voting process itself. And the COC will evaluate and vote on the resolution plans based on the bid evaluation matrix. As I've told you, the bid evaluation matrix we can have several criteria As per the industry, the COC may dictate the criteria according to their preferences and requirements. Supposing if it's a huge real estate company, then it's ideal for the resolution applicant to have that kind of a backing, either to have that kind of funds at their disposal or to have the ability to raise that kind of funds. So, the members of the COC will evaluate based on these criteria and conduct a voting. If they deem it necessary, then they may also conduct negotiation sessions with the resolution applicants, prospective resolution applicants. So this negotiation process can happen in several different criteria, and such negotiation process for negotiation also will have to be explained to the prospective resolution applicants prior to it happening. It can happen either as an open challenge or a one-on-one negotiation. An open challenge is basically where it happens like an auction, where the minimum bid, the maximum bid is informed to the other bidders, and then the other bidders may either match or increase over that available bid. So such bidding process enables them to get a higher recovery. Once a resolution plan is accepted uh, accepted by the members of the committee, then the resolution professional shall file an application of the resolution plan to the NCLT, and within 30 days of such filing of the application, the adjudicating authority will communicate its approval. And this 30-day window is also inclusive of the 330 days period. So let us look at the mandatory contents of a resolution plan. A resolution plan must necessarily contain several aspects. Primarily, it has to cover the insolvency costs. Insolvency costs will include the costs incurred during the process of CIRP, the costs paid to the IRP or the RP, and to the authorized representative in case of a class of creditors, and the costs incurred to conduct the meetings of the COC, the costs incurred for appointing security personnel and registered valuers and transaction auditors and all such other things during the insolvency process. All of these costs will have to be separately noted by the resolution professional. These will also be timely provided to the IBBI and insolvency professional agencies as well by the IRP and the RP. However, this will eventually be included in the insolvency costs, and the resolution applicant, if any pending at that point, will have to include this in the resolution plan. Initially, when the CIRP is commenced, the adjudicating authority, while giving the order of admission of the CIRP, will provide for an amount that is to be given by the applicant for the commencement and initial period of the CIRP. Subsequently, the members may decide either to raise an interim finance or sell a part of the assets, or uh, or use the money that is coming from, if in case the unit is a going concern, the corporate is a going concern, any amounts that are coming from the going concern to conduct the CIRP process. But if any pending, then such costs will also be dealt by the prospective resolution applicant. Then it provides for payment of debts in manner prescribed by the board. So under section 30, the core of the code, the board lays out for payment of debts of different stakeholders in a different manner. So originally, it for primarily first the insolvency cost must be paid, then the debt towards operational creditors must be paid in priority. So any amount that they will be realizing in the event of a liquidation, that is the minimum amount that they have to be given in any resolution plan. Say suppose basing on the liquidation value. So the entity valuation as given by the registered valuers, the entity valuation is the liquidation value. So the liquidation value is the minimum amount that will be realized if the entire assets of the company are sold under liquidation. So that is the base price. That is an amount that will definitely be realized. So taking that as a base, and if that minimum amount is realized, then how you have then under the waterfall mechanism, section 53, which we will get to in the subsequent lectures, the amount that will be realized under section 53 towards operational creditors will be the minimum amount that they are going to be receiving even under a resolution plan. That has to be the minimum. It can be over it, whichever is higher. It's either the liquidation value, or if they have provided for some other value in a resolution plan, then this higher liquidation value will be taken and that will be provided to the operation creditors in priority than the other creditors. After that, the financial creditors and other stakeholders may fall. And the resolution plan must necessarily include provisions for management of the corporate debtor. Management of the corporate debtor subsequent to the conclusion of the CIRP. So it has to include clauses which provide who is going to be in control and management of the corporate debtor subsequent to the CIRP. Such people must also be eligible under 29A. They should not be hit by any of the provisions in 29A. So if they are deemed to be eligible under 29A, they may act as management in the corporate debtor. It is very important because these are going concerns under the CIRP. It is very important that the corporate debtor is taken care of by proper management and a proper plan for the execution of the going concern to be in place. So the members of the committee of creditors must also look into this aspect. Provides for implementation supervision of the plan. So once the resolution plan is approved by the NCLT, the resolution plan must be executed. So for this execution aspect, a neutral third party must also be in place who is going to oversee and supervise this implementation of the resolution plan. And this will be done by an insolvency professional. It can either be the same insolvency professional who has either been the IRP and RP, or just the RP, whoever has been in place so far, can also continue as the insolvency professional who's going to oversee and supervise the execution of the resolution plan. This insolvency professional will be constituting a monitoring committee. Though the code does not explicitly provide for uh, for what and how a monitoring committee is to be constituted, the resolution plan must necessarily include a clause for this and the payment and how and who constitutes a monitoring committee. So monitoring committee like generally consists of an insolvency professional who's going to act as a chairperson, a representative from the resolution applicant, successful resolution applicant, and a representative from the members of the COC. So these three And they may also increase, they can be two representatives from the successful resolution applicant and two representatives from the financial creditors as per their resolution plan and the clauses agreed upon there. And the insolvency professional will be compensated, and such compensation will also be included in the resolution plan itself. So let us understand. Then let us look at various case studies. So let us look at the first one, Mobilox Innovations versus Kirusa Software. So this case, all of these cases are by the Supreme Court itself, and these are the landmark judgments that have laid down the foundations of IBC and the interpretation that came from it. So in Mobilox Innovations versus Kirusa Software, the party, one of the parties was has this was a case of a operational creditor initiating CIRP. So in this, the NCLT has deemed that there was a pre-existing dispute. So the corporate debtor in this instance had an NDA which was supposedly violated by the operational creditor. So the NCLT gave an order stating that there is a pre-existing dispute and hence a CIRP cannot be initiated. However, the NCLT overturned this order and stated that the NCLT cannot make a prima facie judgment like that just because there is just a claim that uh, the NDA has been violated, but no proceedings have been initiated and nothing substantial has come of it. So the NCLAT held that CIRP proceedings may be initiated, and subsequently they appealed to the Supreme Court. So in the Supreme Court, similar contentions were put in, and the court concluded that existence of a dispute, they interpreted the aspect existence of a dispute. It needs to have been communicated to the corporate debtor, which in the corporate debtor needs to communicate to the operational creditor. In this instance, they have made their communication, but the NCLAT was of the opinion that since no legal proceedings are pending, then it may not be considered as a dispute, pre-existing dispute, since nothing has been put into litigation or arbitration. So, however, the Supreme Court has stated that only 2 years have lapsed since the cause of action arose, and there was still 1 year to the limitation period, 1 year or whatever amount of period. The limitation period has not elapsed yet. So there is a dispute, and it is on the corporate debtor to raise such a dispute within the limitation period. So it cannot be such that it cannot be concluded that there is no dispute merely because there is no litigation. The word dispute is wider than that. That is what the Supreme Court has held, and hence the CIRP was not admitted. The NCLAT order was overturned. In the case of Swiss ribbons, the constitutionality of IBC was challenged. So in this case, the appellants had challenged, the petitioners had challenged that the stakeholders are being treated differently and there is no intelligible differentia. If you remember, intelligible differentia has to treat unequals unequally, and equals equally. So it it was sub contended that the stakeholders, say supposing there is different criteria, there is operation creditors and then financial creditors. It was stated that financial creditors were given voting rights and they are being able to realize higher values than that of operation creditors, who are going to realize only the liquidation value, which or more, but they do not have any voting rights. Hence, this is against the constitutionality. There, but the Supreme Court herein held that this the differentiation created between a financial creditor and an operational creditor is very much constitutional and valid, because they are of different natures. The debt provided towards them is of different nature, and the legislature is empowered to create such differences in economic laws to the interest to for the interests of the public. Any such differences in economic laws may be allowed, which provide an which provide differences in unequal categories of creditors. Like in this instance, where financial creditors are, the nature of the debt itself is very different from the nature of debt in a operational creditor. Let us look at the next case law. COC of SR Steel versus Satish Kumar Gupta. So in this case, the Supreme Court held that the members of the commercial wisdom of the Committee of Creditors is has the final decision-making power. They have been granted voting rights in the CIRP process because they are the stakeholders that are whose interest is most at stake. Right. I'm not saying that the employees or the workmen will not be affected on the same scale. They might also be affected in a much graver scale. But in more of an economic standpoint, considering their commercial and business sense and acumen, the financial creditors have been put in that decision-making authority, and they've been given that role. So for their interest, and expecting that they would take a commercial decision in their wisdom, in the interest of other stakeholders as well, the Supreme Court has held that they have the utmost and the final say in deciding upon the resolution plans and such breakdown between the resolution in the resolution plans. If there is any difference in this instance, in this particular case, there was a difference created in different classes of operational creditors. So the Supreme Court held that that was commercial wisdom, and the COC may take its decision based on the viability and feasibility of the resolution plan. Now, coming to the next one, Pioneer Urban Land and Infrastructure Private Limited. So, in this case, the Supreme Court laid down a very landmark judgment. In this case, the Supreme Court recognized home buyers as financial creditors. This was in the making for a few. You can see that this was in the making in a couple of other case laws as well, but this in this case, the Supreme Court identified that home buyers are financial creditors. It held that the initial payment taken by the builder from the allottees will be considered as a debt, with that amount will have a commercial effect of a borrowing, and that at least 70% raised from such allottees will be used towards building and development of the project. Since this This aspect is considered as commercial effect of a borrowing. They are recognized as a financial creditor. Now let us come to the next one. IBBI Singapore. A resolution plan cannot be withdrawn once submitted before the adjudicating authority. A resolution plan is absolute, unconditional, so it cannot be withdrawn. In this instance, because of COVID, the circumstances had changed and the resolution applicant had wished to withdraw the plan. But withdrawing at that instance or changing the amounts involved will cause a grave damage to the corporate debtor and all of the stakeholders involved. So when the resolution applicant is submitting a resolution plan, there is a certain risk involved. This is considered to be a business risk, and the Supreme Court held that a resolution plan is absolute and cannot be withdrawn after filing the resolution plan application before it. And the amounts also may not be changed. And coming to the next one, Rainbow Papers. In this judgment, the Supreme Court held that government dues, which are considered to be statutory dues, if you remember, are considered operational dues. Though government departments are considered operational creditors, if in case the debt owed to them creates a charge on the corporate debtor, they may be considered as a secured creditor as per the waterfall mechanism, and they may be treated accordingly. So, in this particular case, the government department, Gujarat VAT department, had submitted a claim. The GVAT Act, under Section 48 of the Act, creates a charge on the corporate debtor. So this was considered to be a claim from a secured creditor. And so they were treated on par with other secured creditors. Now, let us look at the practical challenges faced. So, ideally, the process must be concluded within 330 days. However, there are several issues in actually finishing it within 30 days. There could be litigation delays, and there could be delays by the resolution professional caused due to various factors, in non-cooperation from the erstwhile management, or suppose they're not able to obtain the documents, or they're not able to force majeure reasons, political disparities. There could be several reasons why they are not able to conduct the CIRP within the timeline. And in a more practical and real aspect, there have been instances where the CIRP processes have been going on for years on end. And the NCLT regularly continues giving the extensions due to whatever reasons. Disputes over valuation of companies. So, in the first place, there are two registered valuers appointed to avoid that there is that avoid the possibility of huge disparities in value. So normally the valuation given by both the registered valuers, the average of it is taken as the valuation of the company. However, if there is huge disparities in valuation, then a third valuer will be appointed, and whoever the third valuer comes closest to among the primary two, those two will be considered. But when it comes to once these long drawn processes takes place, the valuation also may differ. And if the valuation differs, naturally there will be disputes coming of it. Operational creditors receiving lower payout. Operation creditors are not given a very active role even during the process, and subsequently they cannot voice out their opinion, and they're not even receiving higher payouts, ev- despite ordinarily operational creditors are sometimes small time vendors who are unable to sustain their businesses after such setbacks. And if the receivable amount is minimum liquidation amount is what is being given to them, and ordinarily it's not going to be higher than that, because the resolution applicants can get away with giving just the liquidation amount and nothing higher. If it's a going concern, then in the interest of continuing their transactions with the operational creditor, they may give a higher amount, but it that has not that is not how the trend has been noticed. And lack of sufficient resolution applicants, because uh, of the absolute nature of the resolution plan, and because of the long drawn processes, and because of the growing disinterest in investing in stressed asset market, there is lowering number of resolution applicants. And there is also uh, specific industries which face this issue more than the others. However, introducing CIRP mechanism has transformed the insolvency procedures in India drastically, and I would say it is for the better. Even the code might need a little bit of fine tuning, but this is the CIRP process aims for an overall economic development rather than benefiting interests of of a single individual or an entity. So this is a more of a long-term approach, and for the betterment of the economy on whole. Ensures a structured and time-bound resolution as compared to other processes that were in place earlier. This is still slightly quicker, much quicker, I must say, and also provides a singular forum and a structure in which the resolution process has to be conducted. Still faces implementational challenges. So there could be practical aspects where licensing issues and such other issues can come up for the resolution applicants at a later date, and that creates implementational challenges even after the approval of the resolution plan. Future improvements needed in judicial efficiency and resolution timelines. So, as I said, there are certain aspects of the code that need fine tuning, and there is a deficiency in the number of judges sitting, and that naturally results in huge delays in the judicial process itself and delaying the resolution timelines also. So considering all of these, IBC has created a huge shift in the insolvency paradigm in India, but still requires a little change, a little fine tuning. And we will look into the liquidation aspect of the IBC, liquidation of corporate entities, in the subsequent lectures. Thank you very much. Have a good day.